Good afternoon. Well, starting the new series of our video lectures because of the problem which are connected with the uh, how this whole situation, not here in this country but the world. That's why, and now I will try to give such a glimpse on the problem of common part of criminal law, especially for the students of National University Odessa Law Academy. Uh, The first lecture, which I will give in this course, which will be connected with the ideas and the concept of crime. You know that during last semester we were trying to understand what uh, is the essence of criminal law. Sometimes people said that criminal law is a law on punishment, and that's right. The second group said that criminal law is the law on crime. That's always right. The third group said that criminal law is the law on crime and the punishment and other criminal related measures or oppressive measures which are used against well, physical or juridical persons who are not qualified or classified as the subjects of crime. That is why sometimes we use the notion criminal in a very specific manner. This manner depends on two situations or two criteria. One of them is the level. The level means that sometimes we use all the ideas which are connected with crime, punishment, which are connected with the ideas of what should be the criminal in the future or in the nowadays while we classify, well, we're trying to classify, pardon me, all the characteristics of crime. So the idea is in the level. What does it mean? One point of view, and we are saying about the level of criminal regulation, we have some concepts of crime and punishment at the level of international criminal law, supranational criminal law, when we're saying, for example, in the European criminal policy, the European Union, and some elements of European criminal law which are connected to the treaty of association or the Lisbon Treaty as a whole. The case is there that European Union or international society should use specific norms. For example, the norms and characteristics of crime and the main elements of criminal responsibility as corpus delicti, so which is unified or unified the notion of crime as a whole. So the main elements of the crime in international law differs from these elements, as usual, differs from these elements in domestic law. It is not contradictory because, well, international mechanisms were constructed by the way, with the means and with the help of one language, English language. They were constructed with the ideology of English-speaking people, with the ideology of common law countries, and that's why, for example, the traditional dividing of corpus delicti, crime with two elements, subjective and objective elements. That is one point of view. From the second point of view, domestic criminal law in Slavic countries is divided these elements per four, not per two. Domestic criminal law in communist China or in Germany is divided these elements of crime per three. And the next lecture, which will be connected with the grounds of criminal responsibility, will try to analyze them all. But now the idea is that we have separated elements and we have separated ideologies in a different manner. Try to understand that. What you say about that? That crime is a social and legal phenomenon. Social phenomenon because it unified the idea of sovereignty of state, because the state has the right to punish these people. From the other point of view, one could say that there is a gap. International society has the right to punish these people too, or to make some suggestions in this way. What does it mean? For example, when we're saying about European continent, we're saying about European Court of Human Rights, we know that Article 6, the right to fair trial, consists of some elements of protecting the rights of the people in criminal charges. Article 7 of European Convention of Protecting the Human Rights and Fundamental Freedoms said that these elements, especially these elements of understanding of what criminal charges or criminal punishment is, are connected with the main principle of criminal law. We know that nullum crimen, nullum pena, sine lege. It means that one can't be punished without any extent regarding to the notion of crime, regarding to the time of omission, and so on and so forth. The idea is that if a student want to make some additional changes or additional elements and understand what crime is or what notion of crime is in international level, well, means that we have to follow, for example, two specific documents. That's the guide on Article 6 in Criminal Law, which is produced by the European Court of Human Rights, and the guide of Article 7 of European Convention, which is produced by the European Court of Human Rights too. What's the problem? The problem is that in domestic criminal law and in international or supranational at European level understanding of what crime is, there is a gap and there is a difference. What does it mean? Traditionally, we're saying that crime is, and the notion of crime is connected only with one element, with the criminal code of concrete country. And criminal code of concrete country is the main document which unifies the notion of crime. From the position of European Court of Human Rights, it differs each other. For example, if somebody commits a traffic offense, he has the same rights as the guy or girl who commits a crime. For example, something like family violence and so on and so forth, or drug addiction. The case is that for European Court of Human Rights, the notion of criminal, it is not connected with the criminalization. It is not connected especially with criminal code. It is connected with additional elements that is connected with main characteristic of wrongful acts in the society or at the European level. Just try to understand. There is a traditional, very specific and very traditional rule in the European Court of Human Rights, so it's called the Engel Rule. That is the case Engel and others versus Netherlands. And the criteria of this case are used now by European Court of Human Rights, and also will come all society and Ukrainians, especially when some people just produced an act in European Court to produce a specific request to European Court of Human Rights. It is connected with some elements. At first, the applicability to be a crime is connected with the classification in domestic law. Yes, it should be crime. It should be criminal offense, it should be somewhere the element which is it's more sophisticated levels, should say, about administrative offense or disciplinary offense, and so on and so forth. From the other point of view, we could say that the nature of the offense depends on the other characteristics, not only on the classification of in domestic law, but the severity of the offense. Which is connected with the material element of the offense as a whole, because the offense should make specific negative changes to society, negative changes to victims of crime, and so on and so forth, and it should influence to the subject of social relations. That is a traditional material element of crime, which is used to understand what is the nature of offense as a whole. And the last but not the least point of the qualification, that is the severity of the penalty that the person concerned is ensuring. So, classification in domestic law, nature of the offense, severity of the penalty, give us the situation under which we are trying to understand what crime is, or what is the crime in the broad understanding as a whole. Some people said, and the European Court of Human Rights said that some of its decisions and its jurisprudence as a whole, for example, the case of Jussila versus Finland, that we have to take into account the additional elements. First, whether the legal rule in question is directed solely at the specific group, or is it has a generally binding character, whether the proceedings are instituted by public body with the statutory powers of enforcement or not, whether the legal rule has a punitive or deterrent purpose. And next position, whether the legal rule seeks to protect the general interests of society, usually protected by criminal law. That's why these elements as a whole, to my mind, to my position, they are not very specific, but they give us a glimpse under which we will try to give cumulative understanding of what crime in broad sense means. The second element, which is some people said about that, either it is Article 7 or either it is Article 6 of European Convention. It should be the purposes of usage of these elements, because sometimes one could not evolve in this position disciplinary offenses. Sometimes one could not evolve in this position the impeachment. Sometimes one could not involve in this position some dismissional or restriction elements which are connected with the processes of illustration, or restriction, for example, on employment of former KGB officers in Latvia, and so on and so forth. There was a specific case, Sadvaras and Jutas versus Lithuania, Paksas versus Lithuania too, which give us the understanding what criminal offense means or not. So that is one point. International and supranational elements of broad understanding of crime give us the possibility to use the specific forms of protecting of human rights, but it does not give us the understanding of what concept of criminal law is, what concept of crime is in national level. National level of criminal law and national level of understanding what crime is based on material and formal criteria. There are two main elements of it, material and formal. In Article 11 of Criminal Code of Ukraine, this small but a very, very positive book, said us that the crime is a deed which is prohibited by this criminal code. The crime is a deed which was done by the subject of crime. The crime is a deed which was done by the guilty mind subject of crime. And the crime is a deed which produced a negative effect to the society, juridical, physical persons, and so on and so forth. That is why some people said that due to the Soviet era, due to the Soviet period of time, well, it was not only the Soviet period, but the main idea is that crime has its material element. The material element of crime is connected with the severity of social dangerousness of crime. And some people said that is a main position which was produced during years in Ukrainian criminal doctrine, and some people said it now, for that the material understanding of what crime is and the social dangerousness of crime, that's the main criterion which defies crime from and separates crime from another omissions. Is it right or not? From one point, yes. Because national legislation and national understanding of what crime is give us the possibility to show people what is the difference between socially dangerous element and petty offense. From the other points of view, try to understand that in the concept of primarity of human rights, the basic elements, the landscaping element of society's ideology 21st century, one should say that all of these elements and the broad criteria should be protected. That's why, for example, in Ukrainian legislation and in Ukrainian criminal policy, 10 years ago, there was a decision to prepare the reform of criminal justice as a whole. Now you know that the special commission on criminal reform is working in our country, and we do our best, and our colleagues do their best for preparing a new criminal code, which should be qualified as a very specific document regarding the elements of classification of crimes. Just saying some words about classification of crimes. And Article 12 of Criminal Code of Ukraine, nowadays in force, classify the crimes in 4 elements. Not 4 elements, but 4 stages or positions. Petty offenses, medium severity offenses, severe offenses, or like felonies, well, and especially severe offenses. It depends on sanctions, it depends on characteristics of fines, for example, and so on and so forth. But from the other points of view, regarding the ideas of Soviet era, unfortunately, our criminal legislators just say nothing about the characteristics of guiltiness. That's why, for example, criminal negligence well qualified at the same level as the criminal guilty mind of some people. It is not right. It is not, as for my position, it is wrong, and something should be done with these ideas. But that is not the least element, but the element what we are waiting for doing that. One of the main positions of new criminal policy is what should we do with so-called petty offenses. or criminal offense, or crime and criminal offense as a whole, because in 2012, when the Verkhovna Rada of Ukraine has adopted its new criminal procedural code, the notion of petty criminal offense just evolved in this criminal procedural code. It is a very interesting element, and during this period of time, since 2012 to 2014, me and my colleagues were working together for constructing the new criminal code of Ukraine. That's why, for example, we just prepared this book. Well, criminal petty offense, and one part of this book, one third of this part, if I'm not mistaken, was connected with the project or the draft of criminal code of Ukraine. The main idea of this criminal code was that the offenses should be evolved and included in criminal code, and this petty offense should be qualified as petty offense due to characteristics of sanctions, due to characteristics of some additional elements of crime. Now, the people who are working on the drafting of new criminal code said that it would be better to create some books. Yes, one book for petty offenses, one book for crimes, one book for infractions, and so on and so forth. I can say that is the best element, but that is a very huge amount of work that our legislators should do. From one point of view, from the second point of view, try to understand that every prohibition or every restriction of our fundamental rights and freedoms should be done in the manner that should be stated in our Constitution, or the main law. And if it is not done in such a proper manner, there will be a breach of the law. For example, we have the same situation when we say some words about, well, some different laws and ideas under which some of the representatives of governmental bodies were extracted from their work. They were dismissed or restricted to be involved in the situation because of their not of their guilty mind or not of their activity, but because of their position as former governmental bodies. I don't know whether this situation that is right or not, but the decision of European Court of Human Rights regarding the notion and characteristics of lustration and the lustration processes in Ukraine said that it's a very huge gap for our legislators who are doing new elements or responsibility, which was from one element the state responsibility, from the other element it was not connected with the decision of the judge or the decision of the court. That's why it is in a very specific manner it contradicts the Constitution. That's all. It contradicts the Convention, and that's why we have to work separately in every person which was well, a subject of lustration during some periods of time, well, 5 years ago. Well, while we created these elements and while we created this idea of producing new criminal code, we say that the main element of crime should be, well, traditional formal element. The crime should be a deed made by omission or commission made by a subject of crime, which is involved in this criminal code. So unlawful act and unlawfulness should be the main element of crime. As usual, now we're saying our theory, in Ukrainian theory, we're saying about four main elements of crime. That is unlawfulness, this material element, social dangerousness, that is the guiltiness, and this the element of punishability. But the concept of punishment and the concept of punishability, the whole should be very, very specific, because sometimes it is not connected with it. For example, disciplinary proceedings, because these proceedings should be, and sometimes fell within the civil sphere, or and unite in civil and criminal aspects in regard of criminal, not criminal in regard of Article 6 of European Court of Human Rights. Sometimes it should be connected with the proceedings which are disciplinary by its essence, but from the other points of view, they are criminal too. You know, the very popular case, Alexander Volkov versus Ukraine, when a judge was dismissed from this post by Higher Council of Justice of Ukraine, and some people, well, in European Court of Human Rights, said that there was a specific violation of European Convention of Article 6, because in this way it is not a criminal charge, but the person should be protected with all of the elements as the criminal charge is. Well, one main element, what I have to say in this situation, that is the decision of the judge. The court, in the European Court of Human Rights, should distinguish the power of legislator and the privileges. Sometimes we have specific privileges of some members which are not used to define a crime in this situation, because they are not subject to criminal responsibility. Well, sometimes it is connected with the other elements. For example, when we're saying about the severity of penalty, yes, what is the difference between severity of administrative arrest and arrest in criminal law? The term, yes, from one point of view. That's why the European Court of Human Rights, the national courts, Supreme Court of Ukraine now are sitting in the position when we should prohibit, which should be oriented on prohibition in criminal law, because sometimes administrative, tax, customs, financial, competition law proceedings are road traffic offenses, which are punishable by fines or driving restriction, or the offenses in the sphere of plagiarism, or the sphere of higher education. They are not connected with the crime as a whole, but they compelled with them. And that is why we have to understand this broad connection and broad possibility to use with criminal offenses dividing each other. Try to understand that, well, Article 6, for example, of European Convention of Human Rights does not apply to ordinary tax proceedings. But from the other point of view, if the law setting out all the penalties covered to all citizens, their capacity as taxpayers, we should use the same matter for the case. So the criminal nature of offense should be evolved, especially in criminal law, in a special text of criminal law, with the exceptions due to Article 6 and Article 7 of European Court of Human Rights. Material element, well, it's a specific one. It depends on the ideology, and depends on social situation. It depends on, well, very many specific matters and specific elements of life of a society. Well, there is a classical example, for example, when we're saying about material element, when we use this for speculation, which was punishable, well, 20 years ago, and a normal way of doing business now. That is the case. The businesses and speculation. Well, what is the application? The application is connected with the nature of severity, nature of influence, and, well, political understanding of what we are doing in it. Because, for example, an act of corruption or an act of bribery varies in different jurisdictions, but it evolves in the world. And that's why the criminal limb and criminal characteristics of society as a whole should be analyzed from the case of political issues. Sometimes our legislation, well, is connected with the public finding of conflict of interest or impeachment proceedings or electoral sanctions and so on and so forth. That's why we should understand it and should use it with regard, for example, for illustration proceedings, as I say about this deed Polak and others versus Ukraine. That is a very, very specific deed. Some people say that it ends up the illustration process. Nope. The idea of Polak and others versus Ukraine is to apply all the elements of criminal aspect of the situation or criminal law by Article 6 to understand what is material element of crime and should it be involved in this situation. That is the case. Some elements which were at which one should be very specific and to understand are connected with the stages of criminal proceedings and are connected with the characteristics of expulsion and extradition. You know that crimes should differ each other. You know that sometimes, for example, when we're saying about the Article 7 of the European Convention of Human Rights, there is a very interesting gap for political reasons. Paragraph 2 of Article 7. This article shall not prejudice the trial and punishment of any person for any act of omission which at the time when it was committed was criminal according to the general principles of law recognized by civilized nations. That's why, for example, the case of genocide for some people, it's Myanmar, or the problems of elements of crime of genocide in international manner in different parts of former Yugoslavia, or the problems of former responsibility of some leaders in Central Africa. Well, depends on certain circumstances, and these circumstances are connected with the political ideology, the general principles of law recognized by civilized nations. That is additional element with the understanding of what nullum crimen sine lege and nullum bona sine lege means. That is why we'll try to do that. Maybe in the next lecture, well, when I give you a short glimpse of what is criminal responsibility, what are the grounds of criminal responsibility, and what corpus delicti is. That is the very, very, very short and brief trying to give you a short information about what crime is, and we'll develop it in the next lecture. I hope we'll do it during this period of quarantine. Thank you very much for joining. Bye.